Welcome to Work Accident and Occupational Disease Legal Consequences. Participants will gain knowledge about the legal consequences of workplace accidents and occupational diseases. By the end of this training, you will be able to identify workplace accidents and occupational diseases, list the registration and reporting processes, explain the legal consequences from the perspectives of Social Security, criminal law, and contract law, and list the responsibilities and obligations of employers and employees on this subject. According to Article 3G of the Occupational Health and Safety Law number 6331, a workplace accident is an event occurring at the workplace or as a result of work activities that causes death or results in physical or mental disability. Causes of workplace accidents are grouped as follows: personal behavior, 88%; unsafe conditions, 10%; emergency situations, 2%. Any incident that occurs while the insured person is at the workplace is considered a workplace accident, whether or not it is directly related to the work performed. Examples include playing ball in the courtyard, twisting an ankle during a break, falling while picking fruit in the garden, cutting a hand while eating, bee or insect stings in garden/warehouse/production areas, a hand caught in a machine, or electric shock in any area of the workplace. If the insured person is working independently on behalf of and for the account of the employer in connection with the employer's work, any accident occurring in the course of such work is a work accident. Accidents occurring outside the workplace while the insured person is sent by the employer for work-related purposes are considered work accidents. The key point is whether the accident is connected to the assigned task and occurs during the time required to perform that task. Accidents occurring during the time allocated for a breastfeeding insured woman to breastfeed are considered work accidents. Under labor law, breastfeeding leave is part of working hours. Examples include traffic accidents to and from the location of the child and accidents at home while using the daily breastfeeding leave. Accidents during travel to and from the workplace using a vehicle provided by the employer are considered work accidents. Examples: a traffic accident in a company service or rented minibus, injury when getting off a vehicle that hasn't fully stopped, any incident inside the vehicle. However, if an insured person gets off the service vehicle and then has a traffic accident while crossing the road to reach the workplace, it is not a workplace accident because transportation has ceased. The following conditions must be met simultaneously. 1. The person involved must be insured. 2. The insured must be at the workplace or in a location considered part of the workplace. 3. The incident must occur as a result of work carried out by the employer. 4. The accident must result in physical or mental injury. And 5. There must be a reasonable causal link between the accident and the resulting injury. For an incident to count, the damage must result from a work accident. Example: a textile worker not provided with metal gloves suffers a hand cut. In that case, the employer is liable for the worker's injury, not his death. In another case, an insured worker slips off a scaffold. Evaluation is made under Article 13 of the Social Security Law. In short, accident and damage must have a proper causal link. Employers are obliged to audit compliance with occupational health and safety measures and to provide the necessary OHS training. The employer is liable for any damage caused to others by the employee while performing assigned work. The employer is not liable if it proves it selected employees properly, gave the necessary instructions, and supervised/audited them. Unless the employer proves workplace conditions were suitable to prevent the damage, It remains liable to compensate for damage caused by the business's activities. The employer may seek reimbursement from the employee only to the extent of the employee's personal liability. It is employer's responsibility to immediately notify the local law enforcement authorities. 1. Near misses. Incidents that do not result in injury or material damage, even by a hair's breadth. 2. Accidents resulting in property damage, major property losses / minor property damage. 3. Accidents resulting in injuries or death, minor injuries, simple interventions, no lost days. Temporary incapacity / disability, more than 1 day absence from work. Permanent partial disability, permanent disability of an organ. Total disability, serious accidents causing permanent inability to work. 4. Fatal workplace accidents. According to the type of injury, head, eyes, face, neck and spine, shoulder / upper arm / elbow, forearm / wrist / fingers, knee / calves, foot. Internal organs, mental / neurological damage. According to accident type, falls / injuries, falling objects / materials, foreign objects entering the eye, burns, machinery-related accidents, hand tool accidents, electrical accidents, crush injuries, explosions. When a workplace accident occurs, besides injuries and fatalities, there are material losses, visible direct costs, and invisible indirect costs. Visible costs can be listed as death, permanent disability, production stoppage or reduction, permanent disability and death benefit payments, treatment services, temporary inability to work, and other reasons resulting in loss of production and added value. Hidden costs incurred due to workers leaving their jobs during an accident, bringing doctors, vehicles, equipment, transporting the injured, restoring the workplace to a working condition, etc. Workplace accident. An incident at the workplace with the potential to cause injury to the employee, workplace, or equipment. Near miss incident. An event that has potential but does not result in actual harm. Occupational disease is defined in Article 14 of the Social Insurance and General Health Insurance Law No. 5510 as a temporary or permanent illness, physical or mental disability incurred by an insured person due to the nature of the work performed or the conditions under which the work is carried out. In Law No. 6331, Article 3, it is defined as a disease resulting from exposure. For a disease to be considered an occupational disease, certain conditions must be met simultaneously. The person must be insured. The disease or physical / mental disability must be due to the work performed causal link. It must occur within a specific time frame. It must be listed in the annex to the regulation on the procedures for determining the rate of loss of work capacity and earning capacity in the occupation, occur within the specified time frame, and be diagnosed by a medical report from the relevant authority, and the insured must have suffered physical or mental harm. According to the regulation on the procedures for determining the rate of loss of work capacity and earning capacity in the occupation, Annex 2, occupational diseases are classified. Liability periods are defined in the same regulation. Examples: skin cancers 5 years, non-cancerous skin diseases 2 months, hearing loss due to noise 6 months, silicosis / silicotuberculosis 10 years, tetanus 30 days, acute radiation syndrome 2 months. Clinical evaluations, identification of all work activities, workplace exposures, time relationship of symptoms, presence of other workers with similar complaints, non-work related factors, laboratory evaluations, radiological methods, biochemical methods, and pathological examinations. Hearing loss due to noise, disease caused by sudden changes in air pressure. Occupational diseases caused by organic lead compounds, bone and joint damage, and aneurysms caused by vibration, tearing of vertebral processes due to excessive strain, muscle cramps, cataracts caused by infrared rays, occupational skin diseases, diseases caused by ionizing radiation, nerve paralysis due to constant local pressure. The illness or physical/mental disability must have arisen due to work. That is, there must be a causal link between the illness and the work. If it can be stated that the worker would not have contracted the illness without the work performed, a causal link exists. If an employee, under an employment contract, becomes ill due to the nature/conditions of the work or the state of the workplace, a causal link is deemed to exist. An occupational disease must develop within a specific time frame. As stated in Law No. 5510, the illness arises from the nature/conditions of the work or the state of the workplace. The key distinction from a work accident is that occupational disease develops over time rather than within a narrow time frame. The occupational disease must be included in the regulation, must occur within the specified period, and must be determined by the institution's health report. Liability period. The longest period between the date exposure actually occurred leading to the occupational disease and the date the disease occurred. Article 14, final paragraph of Law No. 5510. The circumstances under which an illness is considered an occupational disease. The format/content of the work accident and occupational disease report, the method of submission, and other procedures and principles shall be determined. Disputes shall be decided by the Social Security High Health Council. For a disease to be recognized as an occupational disease, it is not sufficient for it to be included in the list. It must also manifest itself after a certain period of time has elapsed since the worker began working in the job that caused the disease. Exposure period refers to the minimum exposure period required under insurance regulations for a disease to be recognized as an occupational disease. As per Article 14 of Law No. 5510 and Article 36 by 1 of the regulation, determination is by a health report issued by the institution. Article 14 states that the decision that the insured has contracted an occupational disease due to the work they perform is based on an examination of the medical board report prepared in accordance with relevant procedures by health service providers authorized by the institution and supporting medical documents. B. Examination of audit reports and other necessary documents by the institution's health board. Thus, acceptance of occupational disease requires the decision of the Social Security Institution's health board. The liability periods for all occupational diseases are specified in Annex 2 of the Regulation on the procedures for determining the rate of loss of work capacity and earning capacity in the occupation. For instance, the liability period for skin cancer is 5 years, non-cancerous skin diseases 2 months, hearing loss due to noise 6 months, silicosis/silicotuberculosis 10 years, tetanus 30 days, acute radiation syndrome 2 months. The employer must report an occupational disease to the Social Security Institution (SGK) within 3 working days from becoming aware of it. If the insured person is working independently on their own behalf, they must also report to SGK within 3 working days. Healthcare providers must report work-related accidents that occur to them, and authorized healthcare providers must report diagnosed occupational diseases to SGK within 10 days. In the event of a workplace accident, Immediately notify the competent law enforcement authorities at the location of the workplace and to the Social Security institution within 3 working days following the accident. In the case of an occupational disease, the employer must notify the Social Security institution within 3 working days from the date they become aware of the employee's occupational disease or exposure to an occupational hazard. Healthcare service providers must report any workplace accidents that occur to them to the Social Security Institution (SGK) within 10 days. Authorized health service providers must report cases where they diagnose occupational diseases to the SGK within 10 days. Social Security Institution (SGK) Health Assistance provides all necessary health benefits, pays temporary disability benefits, provides income support to the employee or their beneficiaries if work-related accidents WA or occupational diseases OD resulting in harm to the employee. In cases of work-related accidents, occupational diseases, illness, or maternity leave for insured women, the temporary disability allowance to be paid shall be calculated as half of the daily earnings determined in accordance with Article 17 of the law for inpatient treatments and 2/3 for outpatient treatments. When a matter posing a vital danger to employees is identified in the workplace buildings and annexes, working methods and practices, or work equipment, work shall be suspended in part or all of the workplace until the danger is eliminated, taking into account the nature of the vital danger and the area that may be affected by the risk arising from this danger, as well as the employees. The employer is obligated to pay wages to employees who become unemployed due to the suspension of work or to provide them with alternative employment of the same or equivalent nature without any reduction in wages.